Welcome to today's program titled Developments in EEOC Enforcement in Fiscal Year 2023. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. Our presenters will attempt to address questions during the presentation itself, but if they are unable to do so, we will respond to those questions offline. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Chris DeGroff. Chris, please go ahead.
Thanks, Kate. Good afternoon, everyone, or for our West Coast friends, good morning. Would like to welcome everyone to our annual EEOC enforcement webinar. My name is Chris DeGroff. I'm the chair of the firm's complex litigation group, and I also chair the Chicago L&E department. And more importantly for today, for roughly the last 25 years, EEOC litigation has been the vast majority of my practice. This is always one of Seyfarth Shaw's most popular webinars. Almost every employer has had some tangle with this agency. We hope to give you some guidance and some tactics on the EEOC's priorities and strategies. As we've been doing for the last couple of years, we're doing this in a roundtable format with me and my colleagues. So without further ado, I'm going to pass it over to our moderator, James Nassiri.
Thanks so much, Chris. Happy to be here. Hi, everyone. My name is James Nassiri. I'm an associate here in Seyfarth Shaw's Chicago office, and I'm excited to introduce two of our other speakers today. I'd first like to begin with Rachel C. Rachel is senior counsel based out of our Washington, D.C. office. Rachel provides our Seyfarth team and our clients with unparalleled insight into what's ongoing at the EEOC. Rachel comes to Seyfarth after a dozen years of experience leading the enforcement and policy initiatives of both the NLRB and the EEOC. As the EEOC's Assistant General Counsel for Technology, Rachel helped manage the Commission's litigation program. She also served as EEOC management as a special assistant to former EEOC Chair Janet Dillon and as the EEOC's acting executive officer. Before rejoining the Seyfarth team, she led AI policy initiatives as Commissioner Keith Sonderling's senior counsel for AI and algorithmic bias. We're thrilled to have Rachel here. I'd also like to introduce Andy Scroggins. Andy Scroggins is a partner based in the Chicago office. He is a member of the firm's complex discrimination and wage and hour litigation practice groups, and he serves as the coordination partner to facilitate cooperation between the two practices. A significant portion of Andy's practice includes matters concerning the EEOC, including the handling of systemic investigations to pattern and practice litigation. Andy is also the co-editor of this year's Seyfarth Shaw EEOC initiated litigation report. Next slide, please, Kate. Chris, can you tell us what we're going to be discussing today?
Sure. Thanks, James. We're going to be talking about the EEOC's, the personalities behind the EEOC's leadership, the commissioners and the general counsel. We're also going to be taking a peek into the EEOC's enforcement efforts, both through their litigation and charge data. We're also going to dive into how the EEOC resolves cases, be that through conciliation agreements, consent decrees. We find that our clients are particularly interested in that sort of resolution analysis. Of course, like we do every year, we have a deep dive into the EEOC's strategic enforcement priorities. What is the EEOC focused on in 2024 and going forward? We also are going to be really tackling some of the more emergent issues, some of the hot topics for the EEOC in 2024. And we're also going to get our crystal balls out and take a look at what we expect the EEOC is going to be doing from an enforcement standpoint in this year, but also in the years to come.
Sounds like a great program agenda. Thanks, Chris. Rachel, to get us kicked off, can you break down for us some of the key players at the Commission?
Sure. Thanks, James. So good afternoon, good morning, everyone. I'm delighted to be here as part of the Seyfarth team. If we could take the slides down for a second. So the commission is made up of 5 commissioners nominated by the president, confirmed by the Senate. And until August of 2023, there was not a Democratic majority on the commission. And while the commission does many things that are regarded as very political, there are other things that are done on a bipartisan basis or handled by career staff. The litigation program, the majority of the litigation program, I think the folks at EEOC would consider not political or not politically motivated. However, with that 3-2 majority, with that 3-2 Democrat majority, with the Senate's confirmation of Commissioner Kalpana-Kotigal, Chair Burrows, the EEOC chair, was able to push through several 3-2 votes that I think have significant implications for litigation. Those 3-2 votes include the EEOC's strategic plan and the strategic enforcement plan, as well as things like the draft, moving forward, the draft enforcement guidance on sexual harassment, and other documents, some of them fairly obscure for Beltway insiders, such as the regulatory agenda, the submission to the unified agenda, others including even procurement votes on a 3-2 basis. So seeing the Democrat majority really start flexing its muscles and articulating things in that strategic enforcement plan, indicate that we'll see more things that could be interpreted with a political view coming out of the commission. On the litigation front, litigation is conducted by the general counsel. And while we'll talk about the litigation results for FY23, which ends in September, at the end of September, the general counsel, Carla Gilbride, was confirmed by the Senate in October, so in October of 2023. So for almost the entirety of the Biden administration, the EEOC did not have a Senate-confirmed general counsel. So the litigation program, the nuts and bolts, the mechanics of the litigation program were being managed by career staff in the Office of General Counsel, including from headquarters to the regional attorneys to the supervisory trial attorneys on downwards. There are ways that the commission approves litigation, a very complex process that may be revisited soon. But with the general counsel being responsible for conducting litigation, a lot of that is left to career staff. So thinking about the litigation numbers that we're going to be discussing here, that is all before the Senate confirmed general counsel Carla Gilbride came into duty. So with the general counsel joining the leadership team and able to apply her own priorities and exert her own influence on what her litigators are doing, what this 200 plus litigating team is doing in the Office of General Counsel. There's additional leadership and an additional potential for people to show priorities, for these leaders to show their priorities. On the other hand, while there are unquestionably these political or politically interpreted actions going on at the commission, there's also the regular order of business, the regular process of business. And I should mention, by the way, that some of the political things that the commissioners are doing is talking about DEI efforts. So we have Commissioner Andrea Lucas, a Republican, going on Fox News, issuing cautionary statements and fighting with Mark Cuban about DEI issues. And we have Chair Burrows, the Democrat appointed chair of the commission, going on Twitter and voicing her support for DEI efforts. And I think other Democrats, such as Vice Chair Samuels and Commissioner Cottigal, are also voicing their support. So in the public sphere, the commissioners are using their bully pulpit to elevate these issues further. An example of the way the commissioners are using their bully pulpit or saying that they're going to enhance efforts are recent efforts from Commissioner Cottigal, who is presumably getting to know the business of the commission and her role as a commissioner. It was recently announced that she's going to focus on vulnerable workers. And Commissioner Cottigal's efforts with vulnerable workers will include going out into the field and conducting outreach to vulnerable workers and talking about how the commission and the commission's outreach staff can communicate better, can reach out to vulnerable workers, presumably with an eye towards getting them to understand their rights, which would eventually result in more charges being filed and thus down the pipeline, filling up the pipeline for additional litigation. So with that, I'll pass it back to Andy. And Kate, if we could have the slides, and Andy was going to talk about some of the numbers here.
And Rachel, before we do that, real quick, I saw a question come in. Can the president fire a commissioner at will? The answer is no. They stick around for their term, which is why we had such a lag between when the Biden administration took hold and when we actually had a Democrat majority. But it was a great question. Sorry, Andy, go ahead, please.
And of course, we know that the president did fire the EEOC general counsel.
Right.
And so the distinction between the general counsel and the commissioners, that hasn't been litigated, but the general counsel was fired by the president.
Yeah.
Great point.
Well, thank you, Rachel. Always great to get your perspective after spending so much time with the EEOC. Real insider information that I think is valuable for all of us. So I'm going to talk a little bit about EEOC charge filing. And we look at this number because it tells us how the American workers are feeling about the workplace. We'll talk about litigation later, and that really is reflective of EEOC priorities. But it takes an employee to go to the agency to file a charge, employer applicant. And so this gives us a sense of what it is that's on the mind of the worker out there. What we can see is that overall charge activity is held fairly steady over the last few years. You can kind of compare those bars and see that they're relatively equal over time. The largest category of charge that we see are retaliation charges, and I think that probably makes sense for most of those on the call who've experienced receiving EEOC charges. It's quite common for someone who was employed to add on to whatever their charge might be an additional count of retaliation, saying that when they made a report or when the employer discovered that they wanted to file a charge or that they'd suffered some kind of discrimination, that they were then subjected to retaliation. So that's a trend that's been consistent over time. One thing that you'll note over this 3-year period that we're looking at is that sex discrimination charges have dipped somewhat. And I think that's less reflective of fewer sex discrimination charges than the fact that that earlier number that we're seeing is kind of a peak coming off of the Me Too push and seeing a real increase in sex discrimination charges. At that time, we're seeing those come back down more toward the historical norm. We also see age claims have decreased a bit. That's often tied to a better economy. We see more age claims coming out of reductions in force. These numbers do lag, so it'll be interesting to see whether that number for age discrimination claims ticks back up to reflect some of the more turbulent economic times that we've had in the recent past. But the biggest change that I want to focus people on here is this enormous spike in religious discrimination charges. And you can see that we went from fiscal 2020, about 2,000 religious discrimination charges per year, stayed pretty steady the next year. That went up to 14,000 charges in the most recent year that we have data for. That's almost entirely tied to employers rolling out COVID-19 vaccination policies and people seeking exemptions from those policies based on their religious beliefs. Again, when we see another round of these of charge data released, we might see that number come back down to earth as more employers have moved away from the more restrictive policies that we had when vaccines first were rolled out. But it's an interesting trend to keep an eye on, and also significant for employers. The EEOC has not shown a great appetite for taking those charges to litigation by the agency, but we can expect to see many more of those brought to court by private litigants, and those cases are still in their early stages and kind of a mixed bag of case law around the country. What had generally started out as a pretty favorable environment for employers seems to be getting a little more employee friendly as we get some more decisions in, but lots of law still to be made in that area. So if you have one of those charges pending or a lawsuit in the early stages, there's still a lot to be developed here. Why don't we go to the next slide, please, Kate? So we also like to look at where charges are filed. We have talked, Rachel's talked, and we'll talk some more later about the importance of geography to the EEOC, because each EEOC district office does have its own priorities, has its own style and approach to enforcement, including litigation and investigations. So we look first at which states have the most significant numbers of charges. That's on the left-hand side. And no great surprise here, the most populous states tend to have the most charge volume. But if we adjust that, as we've done on the right-hand slide, to account for the population of those states, then we do see some notable patterns, right? And what we see in particular is that the Southeast region of the United States has a much higher rate of charge filing than most of the rest of the country. And so what does that mean to you if you're an employer? Well, if you have operations in one of these states, you need to be more cognizant of the possibility that you're going to be hit with charges from your applicants or employees in those states. It appears that the EEOC may be focusing more on outreach to potential charging parties in those states in order to make people aware of their rights and their ability to raise charges of discrimination to the EEOC for investigation. So a real pattern there, but kind of atypically, we do see that a couple of higher population states, in particular Illinois and Pennsylvania, remain very high in their charge filing, even when we adjust for population. So again, these are pockets where, as an employer, you're more likely to face charge activity. It's also significant because the EEOC's Chicago district office and the Philadelphia district office are among the more aggressive in asserting claims on behalf of charging parties. And so we see sort of a broader pool of charges that are presented to the EEOC in these areas of the country, giving them a bigger pool to pick from when they pursue litigation down the road, as we know both of these offices like to do.
Thanks for that breakdown, Andy. It's interesting to see that even when we factor in population, there's still that pocket of the Southeast that was notably active in terms of charge data this year. We'll also be sure to stay tuned to see whether that surge in religious discrimination charges ends up materializing in the courtroom over the next year or so. So now we've heard some of the highlights from the EEOC's charge data. But Rachel, as we move on to the next slide, can you explain what the numbers tell us about litigation that's being filed by the EEOC?
Sure. So the slide that we see here, the chart that we see here, is really showing us the rhythm, the yearly rhythm of EEOC litigation filing. And as has happened for many, many years, not just the last 4 years on this chart, we see the bulk of litigation being filed at the end of the fiscal year in August and September of the year, and then a slight lull as more litigation gets developed, as you take the pause, you take the breather, and then you look at develop, and you have the career folks in the Office of General Counsel, the litigators looking to develop new cases, additional cases, while handling their existing caseload. We see greater filings in FY23, not just in the aggregate, but also a lot more towards the end there in September. Could it be inferred that knowing that a 5-member commission with a Democrat majority is able to approve litigation, approve some cases that had to be presented, that could be an inference that could be drawn there? But there's also just the regular rhythm of litigation having to be developed, picking things out of the charge pile, working with investigators, issuing the RFIs, and trying to determine if this is a good use of commission resources to bring the suit. And we'll talk more about the strategic enforcement plan and litigation priorities later on in this presentation.
Absolutely. Yeah, September sure is a busy time for EEOC litigation, as we see here. Interesting to see that even as we comb through the last few years, there were nearly as many filings in September of this past year as there were in all of fiscal year 2020, which again, Rachel, goes back to your point that we are looking at a more aggressive EEOC in 2024. Next slide, please, Kate. And Rachel, as we continue with the litigation stats, can you tell us about what types of specific allegations are being most commonly asserted by the Commission?
Sure. So as with the charge data, we do have a breakdown of the claims being asserted in litigation. Of course, Title VII garnering a lot of attention, and so we have, as you see here, Title VII with being the most commonly cited basis, a statutory basis, followed by the Americans with Disabilities Act on disability discrimination claim. So some of these numbers are small. So we have the ADA having one statutory basis in FY21 to climbing up sharply, and so that shows that just because the Commission is silent on litigation on one statute in 1 year doesn't mean that there might not be things in the pipeline or things that they're looking for in that charge pile, in that very large pile of charges, looking for meritorious litigation to bring. Certainly understanding that there's always the potential for a trial attorney, a regional attorney, an investigator to look at a charge and say, we want to take this one and run with it. There remains that level of discretion up and down the chain of command to really develop some of these charges. We
appreciate that helpful breakdown. It's always great to get insights from a true EEOC insider. Thanks, Rachel. As we move ahead, Chris, are there any notable trends when we look at where these cases are being filed around the country?
Sure. I think both Andy and Rachel alluded to this, but let's put a fine point on it. The EEOC is not this monolithic agency. It's divided into these 15 different districts or regions, and each really does have its own personality. They have their own leadership, They have their own advantages and challenges, and their own take on enforcement priorities. There are even regional enforcement plans that are not shared with the public, unlike the strategic enforcement plan that takes hold on a national level. I mentioned in our book, we have a section that maps out the personalities of each of these various districts. And by the way, that book will be going out to everybody at the end of this presentation. So take a look at it if once you get it. But it does, if you have a certain amount of charge volume in a particular district, you can go to that section of the book and see what kind of district you're looking at. Some of these districts are far more aggressive than others. For example, in this last fiscal year, the Philadelphia office filed more lawsuits than the entire Western Seaboard put together. Charlotte had a little bit of a dip. There are some districts, for example, the Chicago office is routinely in the top, so is New York for the number of filings. It really does come down to that old location concept. And knowing the region that you operate in and the region where you're seeing high charge volume will help you understand what the likelihood of EEOC generated litigation might result, but also what various theories the EEOC might be doing significant reach out in. Andy mentioned that in the Southeast, it appears the EEOC might be doing a lot more reach out to employees than perhaps other regions. So pay attention to the location of your charge data.
Thanks, Chris. The other thing I'd like to add is that besides the EEOC's litigators that we see from the regional attorneys and trial attorneys, there's also how do the litigators interact with enforcement personnel doing charge intake, investigating charges. And the relationships between legal and enforcement across the country are very different. And so just as we see the different personalities on the litigators, on the regional attorneys, and with lots of discretion in that regard, there is also discretion and personalities at play from the district directors and enforcement supervisors on down, and how that gets reflected in their priorities versus national priorities. The other thing I said earlier is that one way to think of the Office of General Counsel is that it's a nationwide litigating law firm with over 200 litigators. And I believe that's absolutely true. I wouldn't say if it's not true. And the cross staffing across districts and the who do you give up when the district asks for some additional assistance, there can be friction on that. So, understanding that these offices do have staffing challenge, some of them have staffing challenges, and the EEOC has been on a hiring binge, on a frontline hiring binge in recent years, increasing not just litigation personnel, but enforcement personnel. So I see a lot of the spike in litigation that we've seen in recent years as directly attributable to increased headcount, frontline headcount at the EEOC.
Great. Thank you both so much for those insights. It's fascinating to see the EEOC's East Coast offices really were particularly active this year. It's interesting when you compare it to prior years, we've typically seen West Coast offices like LA and San Francisco be more historically active. This also happens to align with Lex Machina recently published its latest 2023 employment litigation report, and that identified California as a true hotspot for employment litigation. So it's interesting to see kind of the geographic shift towards the East Coast from the commission side. So at this point in the webinar, we've discussed the various types of litigation initiated by the EEOC. But as we move on to the next slide, Chris, how do these cases typically resolve?
Yeah, and thanks, James. Yeah, we've talked about the charges, and the charges grow up to be full-fledged EEOC initiated lawsuits, but where most of our clients and friends who are facing that sort of litigation want to know, how do I get out of it? You know, what's the off ramp? And we can take down that slide. The first way of getting rid of the EEOC case, the way it resolves, is before there's ever a lawsuit to begin with. In other words, there is a charge, the EEOC investigates it, and they come to a determination. In the EEOC's view, there's been a violation of the law. Now, this is the part of the process that really is what the EEOC was originally designed to be about. There were EEO civil rights statutes that were getting pulled on the books, and there was the concern that there was going to be this avalanche of litigation. Enter the EEOC. The idea was that the EEOC as a neutral, don't chuckle, that the EEOC as a neutral would evaluate these claims and then try to seek voluntary compliance. Well, that's what conciliation is all about. The benefit to conciliation is that by statute, it must be confidential. Some folks sometimes come to me and say, how do I make a conciliation agreement confidential? You don't have to do anything. It's automatically confidential. Unless you agree to the EEOC publicizing it, which sometimes happens, and the EEOC has been making more pushes in that direction. They can give you a sweetheart deal if they say, yeah, if you let us do a press release, we'll give you some easy terms. Speaking of terms, what goes into a conciliation agreement commonly? Well, you usually have a change in policies or practices. Training is almost always part of a conciliation agreement. Certain reporting to the EEOC is part of the menu there, and some sort of statement of following the law, a contractual follow the law provision is almost always included in a conciliation agreement. But let's say now you don't conciliate. Conciliation fails. Now the EEOC says we're going to bring a lawsuit. The day after they file a lawsuit, the chance of you getting a settlement agreement that is confidential goes away. There is no way to make or to settle with the EEOC post lawsuit. It has to be done in what's called a consent decree, which is a publicly filed document, and there simply is no way that the EEOC will agree to a consent decree that is private. It's a contradiction in terms. Many of the terms, however, that are in a consent decree are very similar to what you see in the EEOC or in the conciliation stage. So you have those same elements getting laid out, and those, if you want to search PACER or other reporting agencies, you can see what a lot of these consent decrees look like. In the book, we discuss some of the key terms and some of the big 2023 settlements that resolved through consent decrees. There's an off-ramp that doesn't come up very often, but actually it's gaining some popularity, and it's what's called a regular settlement agreement. Now, people say, wait a minute, you don't have a settlement agreement with the EEOC. It's conciliation or a consent decree. Well, there's a stage early in the process before there's even a finding of a determination of discrimination that sometimes the EEOC will say, we want to detach from this, but we want to see if we can get some non-monetary relief for the charging party or charging parties. That is done through a very short form settlement agreement with the EEOC that has sometimes what looks a little bit like a conciliation agreement, but it's only usually a page and a half, very light on the obligations, and it's put together by the folks. Rarely does the EEOC's counsel get deeply involved in the drafting of those. So I doubt most of you have seen that. The only thing, cautionary tale with a settlement agreement, you don't have a finding of discrimination, therefore you have not gone into conciliation. So a settlement agreement, unless you put in a confidentiality provision, is not confidential. And again, this happens rarely, but if there's one point you remember is if you see a settlement agreement come across your desk, just remember you got to put in a confidentiality clause in there. So those are the main ways that these sorts of cases are extinguished one way or another.
Okay. And just to, Chris, to build off that point a bit, one final, albeit very rare instance is a trial judgment. The EEOC
Exactly.
will occasionally be able to obtain a favorable judgment at trial. And as we know, reports show that around 1% of employment cases reach the trial stage. So we're dealing with a small subset of litigation here, but you know, for purposes of comprehension here, we want to note that the EEOC will also request the same types of non-monetary relief post-judgment as it will at a consent decree. So like Chris mentioned, there will be a typical follow the law provision, though they will occasionally request training or policy modifications, anti-discrimination training, reporting requirements, things of that nature. But our analysis looking at these rare occasions shows that courts very rarely grant the EEOC's full scope of non-monetary relief. Courts will generally award a general ban on future discrimination and sometimes will include training or policy modifications, typically lasting about 2 to 3 years. But outside of that, we found very rare occasions where the EEOC will grant the full scope of that non-monetary relief. And this is likely due to the standard that judges are faced with at this point post-trial, which is they look at whether the facts indicate a danger of future violations. And in our view, this suggests that primarily a pattern or practice case would fall into the bucket of, you know, indicating a danger of future violations, such that a court would consider a broader scope of non-monetary relief.
Yeah, and James, that's a great point. And I use this, and I invite you all to use this tactic as well. When you have the EEOC giving you a 15, 20-page conciliation agreement with all the bells and whistles, I commonly ask, can you show me a post-trial judgment? Let's talk about worst case scenarios. Can you show me a post-trial judgment where a judge anywhere in the country has awarded the sort of thing that you're asking for? And the answer is always no, because none exists. You know, some are more aggressive than others. You've got some more beefy post-judgment relief awards than others, but the type of stuff that you're seeing in a proposal from the EEOC at the conciliation stage, no, nothing like that.
That's a great practice point. Thanks, Chris. Next slide, please. So now that we've analyzed EEOC lawsuits from start to finish, we'd like to move on to the Commission's strategic enforcement priorities. And here on the screen, you will see pictured the EEOC's 6 strategic enforcement priorities, otherwise known as the SEPs. And the plan pictured on the screen was released in September of this past year, and it sets out the EEOC's 6 areas of emphasis for its enforcement proceedings from fiscal years 2024 through 2028. At a high level, you can see these priorities include eliminating barriers in recruitment and hiring, protecting vulnerable workers and persons from underserved communities, addressing selected emerging and developing issues, advancing equal pay for all workers, preserving access to the legal system, and preventing and remedying systemic harassment. Our full EEOC-initiated litigation report dives into these priorities in much more detail, but one priority in particular that I'd like to call out here is the EEOC's commitment to addressing emerging and developing issues. As I'm sure everyone on this webinar is well aware, due to consistent changes in politics, government regulations, and the overall culture of the workplace, employment law issues are constantly shifting as well. So along these lines, if we can move to the next slide, please. Rachel, can you please tell us about a few of these emerging issues that employers should have on their radars?
Sure. Before I do that, James, I'd just like to emphasize that when an item is on the strategic enforcement plan, when you have a charge or a piece of litigation coming and being contemplated and fitting into one of these SEP categories, that means that enforcement and litigation is giving it extra attention, that they are actively seeking out charges. They're actively seeking to bring litigation that falls under one of these strategic priorities. But just because you're not in a strategic priority, just because your charge isn't characterized as a strategic charge, doesn't mean that the EEOC is going to ignore you. But if you are in that category, if you are in those, in that strategic category, then you should expect that there will be that extra scrutiny at all levels. So, the first bullet point we have here under emerging issues, LGBTQ issues used to be characterized as emerging issues, and now they're recharacterized as a vulnerable worker population. So you have a little shuffling around in the SEP, saying, but maintaining that charges in alleging discrimination on the basis of sexual orientation or gender identity are still going to fall into one of those strategic priorities. Just because it's in the vulnerable worker box, in the system versus the emerging issues box, I think substantively, you're not going to see that much of a difference on the increased scrutiny that you'll get from frontline personnel. Likewise, the fourth bullet point here talks about AI-related issues, and I should expand that it's not just disability discrimination relating to AI. There certainly was technical assistance that the EEOC issued in May of last year on Title VII and AI, and the year before on the how the Americans with Disabilities Act applies to AI tools that are used in recruiting and screening. Certainly, there have been enthusiastic statements of commitment from Chair Burrows and other commissioners, including on a bipartisan basis, Commissioner Keith Sonderling, my former boss, talking about both the potential benefit of AI and the risks that AI can be used to discriminate. So we have from the EEOC and the SEP their emphasis on the use of technology, including AI, and the applicability of existing civil rights laws of Title VII, the ADA, and the other laws that the EEOC enforces to the results of technology when used for employment decision making. So anything that smacks of technology, any charge that smacks, that smells of technology in employment is going to immediately fall into one of those strategic priorities and get all of that attention from frontline personnel. Let's talk about other priorities. Andy, I think you're raring to jump in here.
Yeah, thanks, Rachel. So another priority that the EEOC identified is this concept of backlash discrimination. And it's when some local or any event really that comes to the attention of the general public causes a response where some people are treated differently and less well. So we've got some ready examples in our recent history. Following 9/11, of course, there was backlash against people of Muslim faith or people who were perceived to be of Muslim faith. So Sikhs, for example, faced a significant uptick in discrimination following 9/11. A more recent example is that many people treated those of Chinese descent less well following COVID, blaming that country for that pandemic that spread around the world. And so the EEOC in the past has sort of defined these groups more specifically, but with this more recent plan has given themselves more wiggle room, just to say we want to be on top of global developments and local responses to those developments in order to be able to step in and try to help people to affirm their rights when they're subjected to discrimination based on, something that has come to the public attention. I think is the best way to describe that.
Yeah, well, those are some great points. Thank you both. I'd like to jump in here quickly on the second bullet point as well, and that is qualification standards and inflexible leave policies. When we compare the EEOC's current strategic enforcement plan to its prior version, this is a priority that really remained largely unchanged across both versions. And based on our analysis of EEOC litigation and media activity, this does not come as a major surprise. The ADA is a consistent point of emphasis for EEOC litigation. Over the past 3 fiscal years, we've seen disability-related lawsuits cover approximately 30 to 35% of total EEOC filings. And just in this past year, several of these ADA filings were touted in EEOC press releases and filed against large nationwide employers that were highlighted on the EEOC's media site. And to further touch on the inflexible leave policies, this is another area that we're consistently seeing litigation filed. This is especially prominent nowadays with the amount of accommodations we're seeing in the workplace. A recent Bureau of Labor Statistics report from 2020 found that nearly 15% of all American workers with a disability have reported seeking some type of change in their current workplace. So this is really top of mind for employers.
So Rachel, you mentioned earlier how Commissioner Lucas has been on Fox News and Chair Burrows has been sort of subtweeting some of her statements around DEI. I wonder if you could speak about that and how it might fit in with the emerging issues that we see in the plan.
Sure. Well, one of the things that the SEP was passed with a 3-2 vote, with the 3 Democrats voting in favor and the 2 Republicans voting against. One of the things that was in the SEP that I think Commissioner Lucas would not, my prediction is that she would have reacted badly to that is in the SEP, it talks about the EEOC using its outreach efforts to conduct outreach about lawful and appropriate DEI programs. The SEP isn't saying that reverse discrimination or, charges or lawsuits alleging so-called reverse discrimination are part of this strategic emphasis, but it is saying that the commission will be conducting outreach on lawful and appropriate DEI programs. I think when you're looking at politically charged charges, charges that have these political interpretations, one of the things to think about is you have career staff with their life perspectives, processing the charges and deciding whether this is something to emphasize, something to in their pile of work to prioritize. And you have that going up and down the chain of command. So, if you have something like one of these politically sensitive charges, there can be pressure from DC, there can be pressure from management to either find them or not find them. And where individual personnel choose to react to that pressure, how they choose to react to that pressure, it can be a very complicated calculus with requiring you to look at who are you, what's the nature of the charge here, and who are the folks that you're dealing with. So one of the other examples that we've seen has to do with religious accommodations due to COVID-19 vaccine mandates. And in the SEP, we have long COVID remaining one of the emerging issues for strategic emphasis, but vaccine accommodations for either disability or religion no longer being part of the strategic emphasis. So that's no longer getting that extra attention. So, that doesn't mean that you're in the clear on those charges. It just means that they're not able to give it, to get the same credit that our frontline personnel wouldn't get the same credit that they would for other things that fit into those strategic areas of strategic emphasis.
If I could jump in just for 1 second, because this seems to me to tee up one of the key takeaways that we want to get across in this webinar, and that is, why do you care, right? The EEOC only files, it's a lot of lawsuits, and it's getting bigger and bigger, and I don't want to be the one that gets tagged, but in the scheme of things, is it likely that any one of you are going to be sued? Probably not. Probably not. There's only so many resources to go around. But what is important is where the EEOC leads, the private counsel, the private plaintiff's bar follows. If there is a lot of smoke around one of these issues, if it's getting a lot of traction with media attention and so forth, it gets the attention of the private plaintiff's bar, and then you see, just like the herd following the leader, a lot of follow-on private lawsuits following these same well-worn strategic areas. And in addition, the EEOC, remember, it doesn't just get its message out through lawsuits, it does grassroots type reach out. And it's going to your employers and saying, hey, have you been sexually harassed? Hey, you should be aware that it is illegal to deny you leave and these sorts of things, right? So even at that level, you're getting more and more attention. So to answer the question, why do I care? It's because even if it's not the EEOC that's bringing the enforcement, right behind it is a bunch of plaintiffs lawyers that would be more than happy to bring a private suit.
Yeah, thank you all. It's very helpful to hear everyone's perspective on these very timely issues, whether it be DE&I or artificial intelligence or overall shifting litigation strategies by the plaintiff's bar. I'm sure these are all topics that are on the radar for in-house counsel. Next slide, please. So for those interested in obtaining CLE credit for this presentation, the CLE code for today is SS, is in Seyfarth Shaw 9325. That's SS 9325. Okay, we can go on to the next slide, please. So Andy and Chris, as we look ahead into 2024, can you tell us what employers should expect from the EEOC going forward?
Go ahead, Andy. You take us out, please.
Oh, sure. So why don't we talk a little bit about what we've seen so far? You may recall, if you've read some of our blog posts or the book, that the EEOC got off to a very slow start last year, filing only really one complaint in the first 4 months, I think, of their fiscal year. That hasn't been the case so far this year. They're off to a pretty rapid start. We've got 8 complaints filed so far. And what I think is notable is that many of them track along with what we would have predicted if we were just going through the strategic enforcement plan. So we see a pay discrimination claim. Those aren't brought that frequently, but this is brought on behalf of a class of women who are working for a school district. So this idea of bringing systemic claims in order to advance the kinds of policy objectives that the EEOC has is reflected in that suit. We also see a class claim brought on behalf of a group of men, Latinos, mostly of Guatemalan descent, in the context of a recycling or scrapyard, where people were treated differently and harassed on account of their sex and their race and their national origin. And then when they tried to make reports of this behavior, suffered retaliation. But again, bringing this kind of systemic charge, and to an earlier questioner asked whether we're seeing cases brought on behalf of men asserting sex harassment. While it's still less common than cases brought on behalf of women, it's not uncommon. Especially we see that in environments like this, like a scrapyard or a construction site, that they're more likely to produce claims of sex harassment by men. Another class claim brought on behalf of women alleging sex harassment coming out of an auto dealership, and we saw several auto dealership claims in the prior fiscal year, and we're seeing that again this year, which I think lines up with the EEOC's notion that they want to try to address discrimination and harassment in work environments where they see that being a repeated pattern. So they've highlighted in particular the construction industry as one target for making sure that there's less discrimination and harassment than they may have seen historically. But I think auto dealerships pop up there quite often. Also, restaurants, and particularly sort of casual or fast food restaurants, are a frequent target. And then stepping back from the, well, I do have one more class claim to point out to you. There's a case involving disability discrimination related to a railroad business that was giving a vision test to conductors and locomotive engineers, and the EEOC is challenging that test, saying that it's not job related, not testing what people need to know in order to perform the job. And again, we saw that reflected on one of our emerging issue slides earlier. So we can already tell that the EEOC is going to have a busy year. They're off to a faster start than usual, and they're bringing more of those kinds of systemic claims that we've seen them use to press their policy objectives. Chris, what are you saying?
Yeah, and Andy, I think there was one. We had some guidance on hearing impaired employees and applicants earlier in between 22 and 23, and the EEOC over the course of the year filed 9 lawsuits based on hearing impairments in recruiting, right? Well, just recently, in the last fiscal year, the EEOC also did a vision impairment guidance. So my pick for 23-24 is, I think we're going to see a lot of discrimination with respect to or claims about vision impairment and recruiting. So if you're getting one of those charges, you're seeing a charge, or if you have some policies that may not be state of the art on that, pay particular attention, because I think the EEOC is looking really hard at those claims right now. One of the things that we wanted to leave with this, what can we do, right? What should we be doing here? I've got 3 big ones. One is track your charge data. Know what your charge data is telling you. I always refer to it as sort of the mine shaft canary of employment law. If you're seeing a bunch of ADA claims, maybe do some training in an area, but you won't know that unless you're tracking your charge data. So make sure that you see, the EEOC is of course paying close attention to these charges, so you should be too. You should consider doing a privileged audit of your policies and practices. Get your counsel to take a look at, do you have the state of the art sort of policies that will get you off the EEOC's radar screen? It doesn't take long. It's not an extremely expensive exercise, but it can save you, not just even with EEOC initiated litigation, but also it can be a prophylactic to private litigation. And finally, training. We beat this drum every year. It's always a good thing to do robust training, state-of-the-art training, the sort of training that EEOC wants you to do, which is to say interactive sorts of training that they are pushing back to live training, but they mean by that is streaming usually. But look for those opportunities. It's great for your defenses to an employment lawsuit, but also it really does have the impact of decreasing the number of lawsuits that you see. So those are my big 3 for ways of dodging the EEOC bullet or a private plaintiff bullet.
Sure. Well, it sounds like 2024 is set to be another busy year for employers. Thank you both for the insights here. Next slide, please, Kate. Before we end today's program, we just like to again call out our EEOC-initiated litigation report pictured here on screen. This is our annual report that tracks all EEOC decisions, filings, and settlements. And our goal here is to create a definitive desk reference on everything EEOC that our clients and employers throughout the country can use as a helpful resource. This year's report was just published in late January and features several new sections regarding case resolution, EEOC media activity, things like that we're very excited to share with the group. And everyone who attended today's webinar will receive a link to access our free report. But you can also access the report through our blog, which is workplaceclassaction.com. workplaceclassaction.com. Chris, before we sign off, do you have any last words for the group?
No, just thanks to everybody. We've been getting some fantastic questions as we've been going along. You could drop the slide. Thanks, Kate. We've been getting some great questions, and a lot of some of what we've been talking about today has been in response to your questions. So thanks for paying attention and hanging in with us. And of course, if you have any follow-up questions, we're always here. But if we didn't get to some of your questions, we'll try to send you an email later on, giving you some answers if we have them. But thanks again for everyone attending. Please feel free to use the desk reference as you need, and we will be back again in 2024 to talk, or sorry, 2025, goodness, to tell you about the year that was and the year to be. But thanks again, and thanks to my co-panelists. You all are superstars. I really appreciate. And James, thanks very much for being our moderator today. And take care, everybody.